through today.
Thanks very much.
Just remind people to turn their phones off or on to silent so they don't interrupt with the recording equipment. The first item of business is apologies. We haven't received any. Sammy Douglas is in another committee, so he may be a little bit late. There's no other apologies, is there? No? Okay. We can move on to the draft minutes. Can I refer members to pages 5 through to 11 of the meeting folders? If you want to glance over those and indicate if you're happy enough for me to sign off in the minutes.
Happy enough, read.
Happy enough, yeah. Matters arising. Patsy, do you want to?
Chair, it's not directly a matter arising from the minutes, but it is from the documents that are in front of us here today.
That's okay, yeah.
Just at page 135 on the Lands Tribunal fees, the valuation issue and the appeals issue, I see there at paragraph 11 that the department says it is recommended the committee members note the response to the consultation. Now, frankly, I've never seen that before from the department. It's usually the committee itself in its own right does these things rather than being directed from any other external bodies, be it department or anything else. So I was just looking to establish, is this new practice by the department in all my time around the building, and I certainly haven't been without my wits whenever I was here. I've really never seen that. I presume, and I hope it's a mistake, but it's from the
Right.
devil.
That's page 135.
135, Chair.
Yeah. On paragraph
11.
11. Yeah.
Perhaps if it had come from yourself, yes,
No,
or the committee, it's a rather unusual approach to things. And especially given the impact and the scale of the fees, which are very substantial for tribunals, for businesses that are often getting it tight, or as we've been sort of taking a whole lot for granted. So, Chair, if I could suggest that we check with the department, is this a new approach or is it a slight mistake?
No, it's okay. I'm happy enough to do it,
Okay.
yeah. And
Thanks, Chair.
to reassure members that we take decisions on whether or not we note things or seek further advice. So happy enough to note that.
Thank you.
Okay. If we move on then to agenda items 4, 5 and 6. So it's oral evidence on the Justice Bill. As I said, there's quite a bit to get through, so if we can keep our questions fairly succinct and indicate early if we want to ask questions in each bit, it would be greatly appreciated. Department officials will attend to outline Part 1 of the Justice Bill, which covers single jurisdiction for county courts and magistrate courts. Part 2, which covers committed for trial. Part 7, covering violent offence prevention orders. Part 8, which is clauses 72 to 76, which cover jury service. Clauses 77 and 78, which cover early guilty pleas. 79 and 80, dealing with avoiding delay. Clause 81, covering public prosecutor's summons. 82, which covers defence access to premises. 83, which covers powers of court security officers, and Part 9, which covers supplementary provisions. So we're going to go through this, and then we've got officials here to outline a new policy amendments relating to PACE and fingerprint DNA retention. So members will have a separate pack which has the bill and relevant information in it, and there's suggested areas that we may want to cover as well during the session. So first of all, we'll do Part 1, which is single jurisdiction for county courts and magistrate courts. Can I welcome Aaron Pearson, Deputy Director of Criminal Justice Policy and Legislation Division, Angela Bell, Jurisdictional Design Branch, Amanda Patterson, Head of Criminal Justice Policy Branch, and Graham Walker, the Justice Bill Manager, to the meeting. You'll be aware that it's being Hansard and will be appearing on the committee website in due course. So whenever you're ready, if you want to briefly outline the purpose of clauses 1 to 6 and Schedule 1 of the bill, which covers single jurisdiction for county courts and magistrate courts, and then we'll open up to questions before we move on to the next part, if that's agreeable. Okay, so whenever you're ready.
Okay, Chair. Karen Pearson from the Department of Justice, and with me on single jurisdiction is Angela Bell. So taking single jurisdiction first, Part 1 of the bill creates a single territorial jurisdiction in Northern Ireland for the county courts and magistrates courts. At present, Northern Ireland is divided into 7 county court divisions and 21 petty session districts by departmental orders. The county court and magistrate court's business is required to be dealt with in a particular division or district, depending, for example, on where the incident occurred or where a party to the proceedings lives. And the bill removes the statutory divisions and allows the county courts and magistrates courts to exercise their jurisdiction throughout the whole of Northern Ireland, bringing them into line with the High Court, the Crown Court and the Coroners' Courts. The bill also provides for a single jurisdiction to be supported by an administrative framework, the purpose of which is to provide a reasonable degree of certainty to court users about where their cases will be heard. Under the framework, the Department will determine new administrative court divisions after appropriate consultation in place of the current statutory ones, and the Lord Chief Justice will issue directions detailing the arrangements for the distribution and transfer of court business. It's intended that current listing arrangements will be largely unchanged. So, for example, an offence which would currently be dealt with in the county court division where the offence occurred or where the defendant resides will instead be dealt with in the administrative court division where the offence occurred or the defendant resides. A key benefit of the new system will be the ability to transfer cases between administrative divisions. This flexibility does not exist at present and will allow cases to be moved where a good reason exists. Details of what a good reason is will be set out in the Lord Chief Justice's directions and will include, for example, where a transfer would better suit the needs of victims and witnesses, perhaps to avail of particular facilities which may not exist in all courthouses. Maintaining court users' access to local justice has been a key consideration during the development of these proposals. It's considered that the Lord Chief Justice's ownership of the listing directions, as well as a requirement for judicial approval, and the opportunity for parties to make representations in relation to the transfer of a case, ought to provide appropriate safeguards in this safeguards for these proposals. I'll finish there, Chair. I'm happy to take any questions.
Okay, Raymond, you'd indicate that.
Thank you very much, Chair. Just a couple of questions. In relation to the observation made by the Public Prosecution Service, where they're saying that they believe that there will be considerable impact on their organisation and resources if we move to the single jurisdiction, what work has been done to sort of alleviate that for the future? Because, I mean, if they're predicting or viewing themselves that they may have difficulties around this, then it might undermine the sort of rationale in terms of access.
Well, there have been some discussions with PPS. I might ask Angela to deal with that.
Yes, after the oral evidence session, we had the opportunity to speak with PPS and we discussed the whole system with them and highlighted that really the single jurisdiction proposals have come about as a result of RPA and the changes to the administrative boundaries in local government districts. And I think they have accepted really that those RPA changes will impact on them as well, and in fact on probably all the criminal justice agencies, and everybody will have to consider their position in light of RPA, which will come into force before the single jurisdiction provisions. So really the single jurisdiction provisions will overlay on top of the RPA, and the RPA would be the catalyst really for any changes. So our view would be that really single jurisdiction in itself isn't going to cause particular problems once RPA is established.
But the PPS are saying, I mean, from their point of view, it seems to be they're saying the single jurisdictions posing a problem rather than RPA.
I think following our discussions with them, they've come to understand that really the sequencing is the other way around. In terms of the Children's Law Centre, they've made a sort of observation around travel. Is there travel costs being built into this reorganisation? Not at this stage, no. It's considered that really any applications to transfer a case will be in the exception rather than as the norm, and they may well be benefit.
Yeah.
The people that are making the applications, so it might be that a child will have to travel a shorter distance to get to court. Yeah. And really, on that basis, we felt that it wasn't really appropriate to start building in extra provisions specifically for travel for children.
Yeah. Is there any provisions built in for travel in any circumstance?
Not really. There will be obviously legal aid available for the cases, and any expenses that would normally be recovered under legal aid will still be recoverable. And if further extra travel costs are incurred in that scenario, then they would be covered.
if we aren't anticipating too much movement, then why would you not build them travel costs for the exceptional circumstances where there will be added journeys?
We really didn't want to set a precedent so that other groups would start to seek the similar.
And when you say our groups,
And any other groups in the children's solicitors were particularly concerned about children. Obviously, if maybe older people started using their
okay, and I think that the last one, sorry, Chair, in relation to the observation that the Attorney General made about the Lord Chief Justice will be given sort of consideration to a lay magistrate being as close to his or her own patches as possible. He's saying that should be a principle written in for all
directions as
solicitors.
well. I think in relation to that, for the lay magistrates, that was specifically included because of the makeup of lay magistrates. And they were under the review of criminal justice back in 2000 set up local to their area when they were dealing with court matters. So we really wanted to maintain that specific aspect of their makeup. But as far as the Lord Chief Justice's directions are concerned, we feel that the fact that the Lord Chief Justice will be issuing those directions provides sufficient cover, and really the draft directions would suggest that there won't be very much change from the current statutory provisions. It'll be an administrative version of what we have at the moment.
And just a general question, the idea of the single jurisdiction, I mean, does that lead people to believe that this might be part of a process which will eventually reduce the number of sites in which there are courthouses?
That wasn't the original intention
Yeah.
of this policy. I think it would be fair to say that potentially there will be a knock-on effect. It certainly wasn't the original intention.
Yeah. But it could be an unintended, it could be a consequence of it?
Well, in fact, at the moment, the number of courthouses could be reduced under the existing statutory provisions, so it wouldn't be predicated on single jurisdiction coming about.
Yeah.
Those changes could be made under current arrangements.
No, but the reason why I say it is that, if you make the case for a single jurisdiction and it's approved, then it might be difficult for people to say, it could be thrown back at you in the future. Well, should you agree to a single jurisdiction, then why do we need multi places to administer justice in a single jurisdiction?
Well, I think the Department would still be very conscious of its statutory duty to provide sufficient access to justice. That would be what we would rely on.
Okay, thank you.
Great. Stuart?
Thank you, Chair, and thank you for presenting the outline of this. Just, but can I just ask you one question that seemed to come through in some of the consultation? Is there a danger that the single jurisdiction places too much emphasis on your administrative benefits rather than the needs of court users?
That will really become more apparent once the Lord Chief Justice issues his directions, which will set out what the reasons for departing from the standard arrangements would be.
Okay.
But I would be hopeful that those will be fairly balanced, and really there won't be an emphasis on court administration being the reason for any moves to take place.
So you can see benefit to end users?
Absolutely.
Okay. Thank you, Chair.
Okay. Alban?
Yes, thank you very much for your presentation and your previous submission in relation to this issue. I've asked before, I'm not absolutely certain, but I've asked before, are the judiciary happy with this? And the answer is yes, I'm told. But, I mean, do we know that the magistrates are happy? Do we know that the county court judges are happy as discrete groups within the judiciary? It's not going to affect the High Court, it's not going to affect the senior judges, it's going to affect the county court judges, crown court judges and the magistrates or the district judges as they now are. I mean, are you content that these different discrete elements have been consulted and are happy?
Yes, we are.
You are content? Yeah. Now, in answer to the question that the Vice Chair put in relation to courthouses and the single jurisdiction, it does seem to me that in the circumstances where the Department is closing courthouses with great enthusiasm, it seems, this would fit into that particular strategy in closing courthouses, because it may not have been intended this way, but it certainly will help, because you can say, yeah, there is a single jurisdiction, so we don't need a court in Ballymena. We don't need a courthouse in Ballymena because, you know, people can go elsewhere, and it's all a single jurisdiction now. I mean, that is, I think, that could be the outworking of this particular change. And I don't think that's particularly helpful to the community at large. I'm making that point to you.
The closure of courthouses is subject to consultation, so that's the process.
It didn't seem that way in the Assembly yesterday when the Justice Minister was replying to questions. He seemed to be fairly adamant. He actually talked about it as being a reform. I can't understand how that term is used. It's certainly a cut, but it can't be seen as a reform because it was not certainly signalled in the process of reforming the system that courthouses would close to the extent that they're being closed.
But there is a consultation at the moment, and our understanding is that the committee is seeing colleagues about that very issue in the middle of March.
Right, yes. Well, you're not the person to answer that particular question.
But on your point, Angela said earlier that if we weren't bringing these proposals forward, courthouse closures are still possible. We understand that we may make the link, but for us they are two separate exercises.
It's fortuitous that these two things coincide.
We have this in front of you for a proposal.
But the main point which has been made, not just by the Law Society, but by others, is that there needs to be a robust set of guidelines to ensure that the assignment of business takes into account the needs of witnesses, the needs of victims of crime, and the needs of defendants as well, because they're entitled to be considered as well. And in terms of ensuring a fair process, and also that flexibility is welcome. It's important that access to justice is promoted through avoiding unnecessarily long journeys for participants in the court process where possible. But, you know, it seems from what is being posed here that there's not really that much by way of protection for people who could be inconvenienced, at the very least inconvenienced, by this single jurisdiction.
The Lord Chief Justice's directions will include a requirement that the parties are consulted or are given an opportunity to make representations when an application is made to move a case to a different division.
Mm-hmm.
We felt that together with the fact that judicial approval will be required.
But if there's only one jurisdiction, as it were, how can you really argue in court to say, well, you know, my case should stay in Enniskillen? You know, you know, the argument will be, well, you know, almost not that far away.
Well, that's the purpose of the administrative directions, that
yes.
The listing arrangements will remain largely as they are at the moment.
But really, at the end of the day, there's no protection for people in this new system. You're at the whim of the administration. You're at the whim of those who are running the system, including the judges, of course.
I would just go back to say that really the purpose of this was to benefit court users, and while I appreciate the scope what you're suggesting, that's certainly not the intention.
The other thing is this, that under this system, county court judges will not have a jurisdiction.
That's right,
they won't have a division.
Work throughout Northern Ireland.
So they can be pushed around the whole of Northern Ireland, willy-nilly. They've no bailiwick at all.
But the Lord Chief Justice will continue to push his directions so that he will decide where they sit. And
So-
the expectation is there won't be a great deal of change.
It gives the Lord Chief Justice a lot of additional clout, doesn't he?
He already does issue the directions for
Yeah.
the
Yes, but if you're appointed to a certain division, within that division, you can exercise your judicial power, as it were, whereas under this system, you don't really have any division, you don't have any seat as such as a judge, and therefore you can just be directed here, there and everywhere.
That's true, but I'm sure there'll be arrangements put in place between the chief and his staff to ease that as much as possible.
Yeah. I just wonder about judicial independence and all of this.
There's nothing that we would be doing in the proposals here that would impact on the ability of the Lord Chief Justice to run the listing arrangements. That would remain absolutely his.
Okay, thanks very much, Chair.
Tom?
Chair, thank you, and thanks for the presentation. Just a couple of quick points. It does say that the Lord Chief Justice may give directions as to a number of areas like the distribution of business, etc. How is it normally operated? I'm assuming it's just a court administration team that direct the business.
At the moment, it's the Lord Chief Justice who issues directions about the distribution of court business. So
it will be the Lord Chief Justice as opposed to maybe?
It will be. It's worded as may, but really, in effect, it will be the Lord Chief Justice.
Okay. But surely, I'm assuming that's the broad principles of what will be of the distribution as opposed to individual cases.
The individual cases would then be subject to any request to depart from the normal arrangements.
Okay. Will this proposal actually give precedent or priority to any type of cases, for example, family courts?
It's not. The directions haven't yet been finalised, and certainly the Lord Chief Justice will be considering whether any particular group would require any priority, but at this stage it's not anticipated that that would happen, unless there is particularly good reason.
And that won't even be contained within regulations, that'll just be left to the authority of the Lord Chief Justice, is that right?
Yes.
Okay. Thanks, Chair.
And under those directions, subject to public consultation?
They may not be subject to public consultation, as the Lord Chief Justice wouldn't be required to publicly consult, but my understanding is that he will consult certainly on a targeted basis with interested parties.
Chair, just on that point, it might be an issue to explore that a wee bit further, even with the Lord Chief Justice, as to how he would do that and how he would take his mind on that issue, because I think it is important as to what might form his thinking around that.
Yeah.
Because we're basically going into a dark corner with this one, and I'm not saying I don't trust the Lord Chief Justice to do it
It
properly,
would
but
be useful to write to him.
it would be useful just to get a view on how he may
Yeah.
take his opinion. Yeah.
Okay.
Thanks.
Okay. If we move on then to Part 7 of the bill, covers violent offences prevention orders. Again, if anybody's any questions, please signal. Whenever you're ready, if you want to outline the purpose of clauses 50 to 71 of the bill, and then we'll take questions.
Okay, thank you. We have Amanda Patterson with us today on behalf. Part 7 will introduce provisions for a violent offences prevention order. This is a new civil order similar to the existing sexual offences prevention order, which the Minister believes will increase the ability of our criminal justice agencies to protect the public from the risk of serious violent harm by those who have already been convicted of violent offences. Having extended the scope of the public protection arrangements to encompass violent offences as well as sexual offences, our aim is to equip those tasked with protecting the public with a similar range of appropriate risk management measures across both categories of offending behaviour. The amendments to the provisions which the Minister intends to table at consideration stage address a number of issues raised by the Attorney-General on possible ECHR compliance concerns. Firstly, we're putting in place a framework which will require any fingerprint, photographic or verification material collected under the VOPO notification provisions to be destroyed when the order expires, unless, in the case of fingerprints, they're being used to replace or update data sets already held under normal place provisions, or in the case of photographic or other information obtained by government departments, the police have applied to the courts and been granted permission to retain such material in the interest of continued public protection. Also included is an amendment to introduce a test of proportionality into the power of the police to enter and search an offender's address if it is somebody else's place of residence. We're also aware of concerns expressed to the committee during the evidence session about the availability of the orders to manage risks from young people under 18. We're very happy to take views and answer questions on that point.
Okay. One of the issues that was raised by Women's Aid was their concern that the threshold of a VOPO would be too high in order to catch domestic violence cases. Have you a response to that concern?
Yeah, the advice from the agencies were that if we put the threshold any lower, which would bring in common assault, it would become unmanageable to a large extent. The VOPO as it stands now has the lowest offence as assault occasioning actual bodily harm in the circumstances of the domestic circumstances, family circumstances and various other ones. And that was considered by the agencies to be where you wanted to set the level. This order is not geared totally for domestic violence cases. It's to deal with people who are presenting a risk of serious violent harm to the community, and whereby you would want to include the serious offenders in terms of domestic violence. So it's not simply to deal with the question of domestic violence.
Is there an argument that there perhaps should be a different category for a domestic violence protection order, as would be the case in other jurisdictions?
Well, I think, although I don't have policy responsibility for that particular area, I understand the department is looking to consult on the area of domestic violence protection orders. The other reason why that would be slightly different is because they would offer immediate protection to an individual in circumstances where the police would arrive at an incident. They could then do something about it with the notice that they would serve. The Violent Offences Prevention Order wouldn't offer that service because it is something that has to be considered by the court on the basis of a conviction.
Okay. Patsy?
Yeah, thanks very much, Chair. It's just around some of the synopsis, supporting evidence or other ways that you have here. To just clarify it, in regard to, it says here the VOPO will be a preventative rather than punitive measure aimed at preventing children from further offending. Reoffending rate for young people 48%. That's higher than that for adult offenders. It also has the potential to prevent young people becoming victims of crime. What does that mean? Can you elaborate on that?
Well, that purely it would be probably an extra additional benefit of the VOPO, whereby the majority of victims of violent crime are young male victims. Right. And we would hope that the imposition of a VOPO or the bringing in of a VOPO would help to prevent crime being committed.
All right, got it, yes. And then further from that, just at the next paragraph down, you refer to the data which would expect that those eligible for a VOPO maybe in the region of 7 per year. This figure is supported by the reoffending pattern of the number of young offenders committed to custody for a violent offence, which would in itself indicate a level of seriousness of and who went on to reoffend. What is that pattern? It refers to a pattern here. Yeah. What is the supported reoffending pattern?
That figure was looked at in a particular 1 year of the number of people who were convicted of a violent offence, which was 21, I think, if I can remember rightly. Right. And that was the number who had reoffended within a period of 18 months, which would suggest that that was the sort of individual, if one was looking at the VOPO applying to young people, it would likely be someone who had had an immediate custodial offence for a violent crime and then had reoffended within a short period. Yeah, so that's where that figure came from. It was designed to illustrate the fact that for under 18s it would be a very, very small percentage of people who would...
But is that the 7 off the 21?
Yeah.
That's 7 out of 21. Okay. Okay, thank you. Thanks, Chair.
Anyone else on this?
Just in relation to the Children's Law Centre and Include Youth, under 18s, what's your view of have you met with?
Yes, we have. Yes, we have indeed. And we understand their position and where they're coming from. I think probably what the department would say is that the concerns that the order would be used indiscriminately for violent offenders, young violent offenders, is probably much misplaced because of that was an example of the sort of numbers that we had thought about. The barrier, if you want to call it, that the court has to use to apply a violent offences prevention order is quite high. It can only be used if there's a risk of serious harm from the individual concerned. Their other concerns were in relation to the fact that there would be other conditions, other licence conditions, other legislative disposals, other sentencing disposals used for young people. And I think our answer to that would be, well, the VOPO, if it isn't needed, it won't be used. Just because it's available doesn't mean that it's going to be used. And the one thing that we bear in mind is that the agencies, the statutory agencies that we consulted with, were able to say to us that they were aware of albeit a very small number of cases, but they were aware of some cases where they would have felt that a VOPO would have been extremely useful in the management of risk of someone under the age of 18. So that's really where this is coming from. If the VOPO isn't needed, it will not be used. The court wouldn't be able to use it, and we wouldn't expect it to be used if there were other licence conditions and other sentencing disposals which could manage the risk. The VOPO is not a sentencing disposal in any event. It's not a punitive disposal. It's purely a risk management tool, and it's purely about protecting the public. Issues that both organisations were talking about in relation to reintegration and rehabilitation of young people, we absolutely accept that is extremely important, and that is what the sentencing disposals and the systems would aim for, whereas the VOPO, which would more or less run in parallel, would be ensuring that the public protection agenda was being followed. And it also may have a positive effect on the ability of parole commissioners to allow for release if they can see that in the community any risk is there, that there are ways of managing it, that there are proper management tools in place for the agencies to manage it. So it may, in fact, enhance an ability to allow for release of a young person.
Just in terms of, I mean, in other aspects of law, there's always a distinction made between, over and under 18. There's no room here to have us bespoke for under 18s.
I'm not sure what it would look like, and that isn't something that has been put forward by either of the two organisations who don't agree with this proposal for under 18s. If there was something else that we could look at, that might be possible, but it's not something that's been put to us. And I would say that in the consultation, in the two targeted consultations which the department undertook following the original consultation on the violent offender order, to all the children's organisations and other ones, other targeted organisations as well, there's no other response received other than from Include Youth and CLC.
Just in terms of the use of the word preventative and punitive, where would one of these orders show and say in terms of a person's no access, if there was a trial done, say like a vetting process for access NI, would a VOPO show up?
don't know, to be honest, I don't know the answer to that, sorry. I don't think so.
Well, I mean, I would say, I'm not making a difference between
Yeah, for
if they had to live in Punilla, but if it showed up in a,
Karen?
you know,
I think it would depend whether it was the normal access and eye check or the enhanced one that we could write
yeah.
about.
It's just in terms of Punilla, because someone might say that, you know, if that's against a person's name and that's a higher, you know, someone looking on would say, well, you know, that's a very rare occasion you get a flop. So, you know, the punitive aspect maybe just, you know, it's, if it's on your record, stays in your record, it meant.
Then the conviction would be the thing that would
Yeah,
be on the
but
record.
flop would, you know, like, as you say, it's only used in certain circumstances, so anybody looking at it would say, you know, it may be a conviction, but it's a
More than happy to find that out for you and let you know. Yeah,
Okay,
more than
thank you.
happy.
No one already else has indicated this part, so if everyone's happy, then move on to part 8, clauses 72 to 76, covering jury service, and clause 82 that covers defence access to premises. So whenever you're ready, if you want to brief us in this section, and we'll open up the question.
Yeah, we'll take juries. The bill makes adjustments to current arrangements for jury service. It abolishes the upper age limit, which is currently 70. It increases the current age for automatic excusal from jury service from 65 to 70, and it makes a number of miscellaneous amendments to the jury's Northern Ireland order to bring it up to date. It's our view that removing age as a barrier to participation in this aspect of civil society is a good step. We're aware that the Commissioner for Older People has suggested a full EQIA should be undertaken to ensure that people aged between 65 and 70 are not disproportionately affected by the amendment. We weren't planning to take that step, Chair. An EQIA on the bill has already concluded that there is a disproportionate impact on those aged over 70 who will be entitled to serve as jurors, whereas currently they are not. I would say this is not a negative impact. It means that a person aged 71 now has a choice previously denied to them, and the choice is theirs to exercise. And in respect of those aged 65 to 70, while automatic excusal will no longer be available, there will be a general discretion to excuse them from service should they so request.
Okay. Any questions, members? Happy enough? I didn't realise she's raised at that point, so that's great. Okay. Can I thank Aaron, Angela and Amanda. Graham, you're staying with us for the next section.
I think, Chair, we've got defence access for you as well.
Oh, sorry. Yes, go ahead.
Okay. The bill also makes provision for the defendant to be able to apply to a court for access to premises for the purpose of preparing his defence. This provision was requested to plug a technical gap. The provision would allow recourse to the court should agreement not be given. The Attorney-General recommended an amendment to the clause as drafted to strengthen the threshold for application. It's the AG's view that a higher test is needed to balance the rights of the occupier of the premises. Instead of requiring access in connection with the preparation of his defence, the Attorney's view is that an application should only be granted to ensure compliance with the fair trial rights of the defendant. We accept the Attorney's view, and we would be content to bring forward the amendment that we've shared with the committee for today.
Okay. Any issues?
How would this pan out in reality? Could you give us an example?
I think at the moment the defendant would normally agree with the prosecution that they can go and inspect the crime scene, basically the crime scene.
Yes.
And that's very rarely an issue. So this ability to apply to the court for a court order will really only be used in those very rare occasions should that not be agreed. It could happen at any point during the proceedings, just whenever the defendant decided he needed to go and inspect the premises. It would be by way of an application to the court.
And in terms of human rights, for example, if you had a dwelling where the defendant lived with a family, for example, would they have access to the entirety of the dwelling, or just the part of the dwelling that is used by the individual? For example, the individual's bedroom, and say he had a 13 or 14-year-old sister, would you then have access to the entirety of the dwelling? Because obviously people could be storing drugs in other parts of the home.
It would be a matter for the court to direct what conditions it wanted to apply with the order. So the order could allow access to the whole of the premises or to a particular part of the premises. it could require the defendant to be accompanied at all times by a police officer. There are certain safeguards built in there for the occupier, so they would also be entitled to make representations to the court before
Yes.
the order is made.
But it would have the capacity to search the entirety of an individual dwelling in that
So
particular
it's not
instance?
so much for a search as just for a visit
Okay,
to sort of view the premises.
okay. All right, thank you.
Okay, thanks. Anyone else? Okay, thank you very much. Graham's going to stay with us then, and we're going to bring Moira Campbell, Deputy Director of Criminal Justice Development Division, to the table as well. Okay, members, we're going to move on to part 2 of the bill, which covers committal for trial. Whenever you're ready, if you want to outline the purpose of clauses 7 to 16 and schedules 2 and 3 of the bill, which cover committal for trial, and then we'll open up for questions.
Okay, thank you very much, Chairman. This session is covering a number of measures designed to speed up the justice system. Part 2 of the bill, which provides for the reform of the committal process. I think I'm safe in using the word reform in this particular context. And also 5 clauses in Part 8 of the bill covering early guilty pleas, a statutory framework for the management of criminal cases, also referred to as statutory case management, and the public prosecutor's summons. Starting with Part 2 then, these clauses aim to streamline the procedure for moving business from the Magistrates' Court to the Crown Court. Under the current arrangements, the committal stage is used to determine whether there is sufficient evidence to justify putting a person on trial in the Crown Court. This can be done in a couple of ways. Preliminary investigation, or PI, where witnesses are required to give oral evidence and be cross-examined, or a preliminary inquiry, or PE, which is essentially a paper exercise. We've also what are known as mixed committals, which are effectively a combination of the two. Most cases proceed by way of PE, preliminary inquiry, in practice. Clauses 7 and 8 would abolish preliminary investigations, PIs, and mixed committals, and this is in direct response to feedback from victims' organisations about the impact on victims of having to give their oral evidence in court twice. This can be traumatic, especially for victims of sexual crime or other vulnerable witnesses, and feel a bit like a trial within a trial for them. Clause 11 would allow cases to be directly transferred to the Crown Court where the defendant has indicated that he or she intends to plead guilty at arraignment. Clause 12 provides for the direct transfer of a specified offence, and at this stage we're proposing this should only apply to murder and manslaughter cases, though the intention would be to add to the list of specified offences over time. As you might expect, there was a range of views expressed during consultation. For example, the Law Society, while they acknowledged the concerns around vulnerable witnesses, suggested it would be preferable to build on existing court rules which allow for certain exceptions and to give more discretion to district judges to allow oral evidence to be given at committal if the interests of justice required that. On the other hand, the Public Prosecution Service commented that the proposals in the bill were more limited than they would have liked, and they called for committal to be abolished altogether. Victim Support NI also said that it favoured outright abolition, but they had no fundamental objection to a staged and gradual transition along the lines we were proposing. We did note in our response that outright abolition is the Minister's ultimate aim, once it's clear that the system has the ability to cope, and in the interim we feel that our proposals are striking the right balance. The PPS also suggested that Clause 12 could usefully be amended to enable the direct transfer of a co-defendant who's been charged with a non-specified offence, and we'd be happy to explore that today with the committee, and if you were minded to accept the need for an amendment, we could look to bring that forward at consideration stage. And I'll pause here to take questions on Part 2 before we move on to the other provisions.
Yeah, that's okay. You mentioned Clause 12.4, which enables the Department to amend the list of specified offences by way of an order. Would there be any limitations on that, or is there any role for the Assembly in terms of part of the Department?
The Assembly procedure that would attract would be the affirmative resolution procedure.
Okay.
So there would be an opportunity for the Assembly to debate that in full.
Okay. And Marie had mentioned that the Minister's aim is to remove the committal proceedings entirely. When would you anticipate that the criminal justice system would have the capacity to do that?
We don't have an agreed time frame for that as yet. I think we would need to see how well we managed with the direct transfer of murder manslaughter cases in the first instance, and I think it would depend probably on what progress we might make with some of the other reforms as well. For instance, if we had a large proportion of defendants entering an earlier guilty plea, which would take a lot of clutter out of the system, then it might actually free up resources to start transferring more cases into the Crown that do need to go for contest. So I think it'll be a combination of factors that will determine that. And I think the advice from the Office of Lord Chief Justice was that we should start with a smaller volume of those higher end cases and see how that progresses before we would make any decisions about how quickly we'd move to add other offences. But at least we have the headroom to do that here through this provision. But as Graham says, that will be managed through coming back to you in terms of proposals for what else might be added to that.
Okay. Great.
Just in an overall sense, how does this improve the justice system by the long-term goal of abolishing committal proceedings? If someone asks you how does that, does it make it more streamlined? Does it speed up the process?
Well, our main driver was the impact on the victim, because this originally came out of a focus group we had with a range of victims' organisations, and Victim Support and Nexus in particular were very keen for us to address this. But we do feel that it has the potential, particularly in the circumstances I talked about, where we are able to differentiate at an earlier stage between early pleas and contests. It could actually remove something that's a bit of a speed bump at the moment in cases that could be got to Crown Court more readily. We've been saying that in a pilot exercise that we're doing in indictable cases in Paris Criminal Division. That's just commenced since the 2nd of January, so it's still very early days, but already we're getting cases into court quite quickly, but even where a person has indicated very early on that they wish to plead guilty, we still have the requirement to go through the committal process, and if we didn't have to do that and could directly transfer them, there are potentially a lot of benefits, not just in court time, but also to the police and prosecution in proceeding by way of a streamlined file as opposed to having to produce a full file, which can take a considerable amount of time. It also reduces the need to commission forensic exhibits and medical reports and all of that, which are part of the reasons for delays at the moment.
You see, the reason why I asked it, because I think, the finding of vulnerable witness would be relatively easy. I mean, I can understand the situation where someone, particularly who's given evidence in a rape trial, then the idea of the sort of trial within a trial, and a witness having been put through it twice or whatever. But in our case, say it's a police officer or a forensic officer is the main basis, then you can see the value of a committal trial to actually prevent you from going to the Crown Court.
In theory at least, but in practice what we've found is that very few cases that end up being weeded out as a result of the committal process.
In terms of, Mr. McCartney, in terms of the number of cases in a particular year, if we were to look at 2013, out of a total number of 1,743 cases that went through the committal process, there's only 51 that weren't actually returned for trial. In other words, weren't sent to the Crown Court.
Yeah.
That's something like 2.9%. Yeah. So it doesn't weed out a huge amount of cases. So in terms of an effective filter, it's not terribly effective.
And bear in mind there are other ways in which cases could be taken out, either through the defendant being discharged in the magistrate's court or the no bill procedure. We feel there are other mechanisms for safeguarding the defendant's right in those cases.
No, I understand that, but I'm saying, 51 isn't, in terms of the overall figure, but still, it's still a high number of cases where someone isn't kept in the system isn't kept going for whatever number of weeks. So, I agree. I agree in principle. In terms of vulnerable witnesses, there shouldn't be a committal because you're putting someone through it unnecessarily. Might even give a person, if you like, a potential witness off because their experience the first time might even reduce their ability to do it the second time and not want to do it the second time, etc., etc. But also to make sure that the system just doesn't see it. It's a run through. Then there must be something somewhere along the line to measure. If the case has been made sufficient enough to go to the Crown Court, then we don't end up with, a high number of cases, especially now you're putting in a system of early guilty pleas, which might weed out. So it's trying to come up with that sort of idea of the committal, and
I think there's a couple of issues there. Once the defendant is returned, sent to the Crown Court for trial, they can make an application for what's more referred to as a no bill, which is essentially an application to the Crown Court judge before trial that the evidence that was disclosed at committal doesn't constitute a prima facie case. So it isn't the case that these reforms would mean that there would be a great number of cases going to a nugatory trial, because once they're sent to the Crown Court, if the defence feels, hang on, the defendant really shouldn't be here, they can make that application for a no bill. And it's essentially the same test at no bill as it would have been at committal, simply that the papers don't disclose a case. Yeah. In terms of the direct transfer provisions that we're proposing for murder and manslaughter, the clauses provide for an application to dismiss. So it's essentially the same principle, that once the papers are served on the defendant, the defence can make an application to the Crown Court judge to say that the case against the defendant is dismissed. So again, even through that process, it shouldn't entail nugatory trials, because if there clearly isn't a case to be answered, those applications will be made to the Crown Court judge.
Yeah. I mean, when this committee did the inquiry in and around the experience of witnesses and victims, I mean, one of the sort of consistent observations through criticism was the length of time it took for, from a person being charged until trial. So whatever, views or reservations or that you put in this particular thing, can we safely say that this will ensure that trials happen quicker?
It should help with speeding cases up. And we're also mindful that if you look at other jurisdictions in these islands, they don't have a committal process. It's been removed in the Republic, England and Wales, and
Scotland had a very different process to begin with.
Something different, but they don't have something comparable. So we think that in terms of getting the balance between the rights of the defendant versus impact on victims and witnesses, we feel that this is proportionate. And should, as you say, address the principal concern of victims, which is just the sheer length of time it takes to get cases through.
The other thing that I would add to that is in terms of delay and in terms of addressing avoidable delay. Although there aren't a great deal of cases that proceed by way of a mixed committal or a PI, the difficulty is that once the defence says, I want this to go by way of PE, or I'm objecting to all the witnesses, or I'm objecting to some of the witnesses, the case is then set up for a PI or mixed committal. So that necessitates quite often a couple of days of court diary. So it may mean that because the court diary is already full, the difficulty is it could be maybe 6 or 8 weeks before you get a date for the PI or the mixed committal. And what invariably happens is that on the day, the defence will quite often say, you know what, let's just let this go through on the papers. So the fact that we would be moving in the interim to a situation where all cases, bar murder and manslaughter, would be simply going through on the papers would remove that potential blockage.
Presently, I mean, the number of applications for a no bill as soon would be low.
Yes.
If this new system comes in, do you expect that to increase then?
I wouldn't necessarily expect it to increase. the figures, I mean, the figures in front of me here, in terms of the number of Nobel applications that are made in a particular year. And I've tried to drill into them to see whether you're more likely to get a Nobel if your case went through as a PE or your case went through as a PI. And out of 2014, out of just over 1,500 cases, there were 27 PIs. 9 of those went to a Nobel, which is 33%. 21 cases originated by way of a mixed committal. 5 of those went to Nobel, which is almost 24%. Out of just over 1,453 cases that originated by way of PE, 154 went by way of a Nobel. That's just over 10%. So I suppose the point is it doesn't really matter how your case originated. There's still the opportunity to Nobel it.
Yeah. And then in the future, what's your overall, what's your analysis going to be? Like, what are you looking to see coming out of this?
So it's difficult to sort of put any hard figures around amount of time saved or cost saved. Obviously, we'll be wanting to monitor this along with the other reforms that we're making. And it's very difficult to isolate one particular factor that helped a case go through more quickly. But we will be seeking, and we have the capacity to measure what impact it looks to have. I suppose the sort of work we're doing on a pilot basis might help us to look in more depth at particular cases and see what it is that has helped to get them through more quickly. And initially that will be with a committal procedure in place, but we'll be able to sort of adopt maybe a similar process when we start to take this out. Given that it's going to be a relatively small number of cases initially that will be directly transferring, we should be able to look at those in some depth just to see exactly what impact it's had in comparison with what would typically be happening in a case of that nature.
Okay, thank you. Sarah, thank you.
Alban?
Thanks very much. The whole purpose of committal proceedings is really to act as a filtering system so that weak cases can be examined. Effectively, weak cases can be examined, or questionable cases can be examined at an early stage, so that a court can decide whether or not a person should go to trial. I mean, what's wrong with that?
I suppose the real purpose is to see is there a prima facie case. It's not to sort of test the reliability of the witness or the strength of the evidence so much, because that's really properly the role of the trial. So. Yes, it is about looking at the prima facie case, but we think there are other safeguards in place that can be used to weed out those cases without interrupting the rights of the defendant.
Yes, but you want to abolish any process of filtering.
It's not so much that we're taking out any opportunity for filtering, because there are those other processes that effectively
not until you get to the Crown Court.
But we'll be retaining PE for all cases.
Yes, but you're saying that, I mean, the PE is simply on the papers, right? You're saying you can make an application at a PE for dismissal of the case?
Absolutely. I mean,
You're retaining that?
The district judge will retain their power to discharge the defendant.
Say the district judge says, well, witness A says such and such, and I haven't had the opportunity to hear him or her, and if I did hear him or her, well, I might have a different opinion, but I haven't heard them, so this will just go to trial. I mean, what purpose is served there?
But that, I mean, that's essentially what happens in the vast majority of cases at the moment. And even in terms of whether it's a PE or a PI or a mixed committal, in practice, the district judge having either a mixed committal or a PI having heard the prosecution evidence, or in a PE having simply just read the prosecution evidence, decides at that point whether the prima facie case exists, and does so before hearing any evidence on behalf of the defendant. So that they're essentially they're deciding that there is or is not a prima facie case before they take it any further. Before the defence is...
But if there's a preliminary investigation, the magistrate's hearing the evidence.
Yes, but again, in practice, the way the legislation is construed, it's only once the district judge has heard the evidence on behalf of the prosecution and then decides whether there's a prima facie case, he or she then invites evidence from the defence. So they've already decided that...
No, I'm not talking about evidence from the defence. I'm talking about the examination of prosecution witnesses. It seems to me, fundamentally, if you've got a filtering system that separates basically good cases from bad cases in terms of, a prima facie case that should properly be prosecuted, it seems to me that that's a very sensible system. And most cases, you're talking about, 1,700 cases, 1,743 cases. They were all of them PEs or a mixture of PEs and PIs?
I think that's the 2013 figures.
Yes.
42 of those were PIs and 31 were mixed committals.
Right, so 70 out of that lot were proceeded with in terms of hearing some evidence.
Well, I can't say that with any degree of certainty.
Well,
what I could say is that they're listed as a PI.
Well, no, I accept your point that sometimes you get to a stage where they say, well, we'll just decide this on the papers. But out of 1,740 cases, you've got 70 cases that went through an actual committal of some sort, right? And that's a very small percentage. It's not as if, you've got hundreds of cases here clogging up the system. It's a very, very small percentage. And I'm just wondering why you want to eliminate that when this is serving a good purpose. In other words, you're getting rid of bad cases that shouldn't be prosecuted.
There's another way of coming at it.
Okay, sorry, Ms. Campbell. I just want to ask one further question, then come back, and that is this: out of the 70 cases that were heard, how many of them ended up with people, the charges against people being dismissed or trial not proceeded with?
I don't have those figures.
It'd be interesting just to find out. That'd be useful, I think.
Certainly in 2013, in that year, there was only 2.9% of cases that were not returned for trial.
Yes, that was 51.
51.
51, so that might be 51 people out of that 70, or might be 51 out of those 70 cases that were not proceeded with.
Will be 51 out of a larger number of cases.
Well, perhaps you can come back to that. I don't want to get bogged down in that, but sorry, I interrupted Ms. Campbell.
Just, your point there about if you don't hear the oral evidence, you're missing an opportunity to weed out cases. I suppose what it comes back to is whether the opportunity to weed out a relatively small number of cases through that process is proportionate when you look at it against the impact on the victim, and I suppose that's really where we're coming from. And bear in mind Mr. McCartney's point about attrition, and there is evidence from the victims' organisations that having to go through the committal process can lead to attrition in a number of cases, particularly in serious sexual assault cases. So really what we've looked at is looking at this in the round, looking at both the victim perspective and also the efficient administration of justice. We've come down in favour of taking out the oral evidence section of this because we think it's proportionate to do that.
But in dealing with sexual cases, no cross-examination. Are there provisions to prevent a cross-examination taking place? Is that not right?
I know there are certain protections in place for vulnerable witnesses, but the feedback we're getting from the victims' organisations is having to go through that process.
But no cross-examination takes place. Surely that meets the need of a vulnerable witness. I'm in favour of protecting vulnerable witnesses. I think the court should have that authority, that discretion to prevent a vulnerable witness being cross-examined. particularly in sexual cases.
Those rules only relate to witnesses up to the age of 17 and don't.
So adult witnesses can be.
Well, I'm not sure
Trying to
about
give
that, but
evidence,
I'm
that's
subject to your greater knowledge of the matter. But in any event, what I'm saying to you is that this is a process which can be helpful for the administration of justice. I don't think it unduly hampers the expeditious processing of court cases. And I'm not sure you're going to save much anyway by this. I suppose that's contrary to my own argument, but nonetheless, I'm saying that really this could be helpful to weed out bad cases, and I think at very least a mixed committal should remain. In other words, there should be an opportunity not to examine all witnesses, but some specified witnesses that are central or core to the prosecution.
Certainly take that point. The only thing I would say is that obviously the defendant will still be entitled to make an application for no bill once transferred to the Crown Court. So
yes. Well, that's the other point I'm going to make, Chair, that you may see an increase of people applying for no bills in the Crown Court, and you may at that point in time have further delays in the Crown Court in relation to cases that haven't been properly filtered through a committal process.
I think that's unlikely, hopefully, in the case of an early guilty plea, and obviously when we introduce this for murder-manslaughter cases, we'll need to monitor that to see what happens in practice.
Of course. And at a no-bill stage, I'm not sure about this, but is there an opportunity to call witnesses?
No. There isn't. The Crown Court judge simply considers the papers that were tendered at committal.
But you see, that's a weakness in terms of, certainly from a defence point of view. If you're on trial and you're saying, well, witness X is a bad witness, and that's central to the prosecution case, you apply to the judge, and the judge says, well, we'll hear this case, and you'll have an opportunity to cross-examine this person in the course of the trial. But, I mean, surely that's not satisfactory.
Though arguably the correct forum for testing the credibility of witnesses is actually at the trial itself, as opposed to in the preliminary proceedings.
Yeah.
And
arguably.
And also, arguably, it's the role of the PPS to ensure that in bringing forward a case, it meets the public interest test, including the prudential test, and that witnesses are going to be capable of giving more evidence.
The PPS, in their submissions and their comments on all of this, are gung-ho in favour of getting rid of committal proceedings, which surprises me, because I would have thought the PPS would have viewed this as a public duty to examine cases at an earlier stage to ensure that, in fact, proper prosecutions are brought.
I think the PPS are very mindful of the resource requirement of preparing for committal, which can be almost as great as preparing for the trial itself in certain circumstances. So I think their hope is that the abolition of committal would really reduce that overhead for them.
Can I ask you a very minor, probably a silly point? Why do you spell inquiry with an I and not an E?
Well, you're not
a silly question.
It's a question to which I once may have known the answer.
Yeah, because if you look at what the various legal bodies are saying, they all talk about PEs, and indeed during the course of your submissions you were talking about PEs, but in the Act Or in the bill, it's PI. It's inquiry beginning with an I.
Yeah, and the 1981 order, the Magistrates Court order, has inquiry with an I as well. I think it's grown up that it's been called a PE to differentiate it from the other PI.
It's been privatised.
Possibly.
Thanks very much.
Very technical.
Well, there you are.
Move on before we get into a debate about apostrophes and things like that. No other members in this section? No? Happy enough to move on. Okay then, can we move on then to Part 8, clauses 77, 78, which cover early guilty plea. So again, whenever you're ready, if you just want to brief us and we'll open up the questions.
Certainly, yes. These are two statutory provisions intended to encourage the use of earlier guilty pleas, and they're intended to complement the approaches we've been developing in parallel on a non-statutory basis. The provisions will require a sentencing court to state the sentence that would have been imposed if a guilty plea had been entered at the earliest reasonable opportunity, and also place a duty on a defence solicitor to advise a client about the benefits of an early guilty plea. We've made you aware of our intention to make a small adjustment to Clause 78, and that's to remove a regulation-making power, which the Attorney-General advised wasn't required. A number of issues were raised during your consultation, and those included how much impact the provisions would have in practice, whether the duty on solicitors should also apply to advocates, and when the earliest reasonable opportunity to enter a guilty plea might be. That's just a very brief overview of the provisions, and happy to take questions on those.
Okay, Stuart.
Just very, very briefly, while I appreciate the value of early guilty pleas, can I just ask where the protections are for children and vulnerable adults in terms of early guilty pleas? Because I think all the evidence would indicate that those are the types of people who would be most likely to admit to something, but in fact there's no requirement to do that at all.
I would absolutely agree with that, that what we don't want is to people feel somehow being coerced into entering an early guilty plea. It's about speeding up justice but not expedient justice, and certainly I think the police would and PPS would be encouraging people to take advice from the legal representative before they would decide how to enter a plea. In the pilot we referred to, we've been piloting a sentencing statement which outlines, after a police caution but before the start of police interview, in detail for an accused, what the implications might be of entering an early plea, but also reminding them if you're not guilty of the offence, you should not plead guilty to it. Now, it seems like a fairly obvious statement, but for someone who's vulnerable, they may need that spelled out for them. If someone's particularly suggestible or might want to give the answer that they think is expected, you have to make that absolutely clear. And I think the statement actually reinforces that point a couple of times. And if the police felt that someone wasn't able to make an informed decision, I think they would certainly be trying to ensure that they have proper legal representation or the support of an appropriate adult at that stage to make sure that their rights are being safeguarded. So I think you're absolutely right. It's an important point that we don't want those who are more vulnerable to just go with the flow and maybe confess to something that they didn't do, or to confess to the wrong charge. Maybe they did do something, but it wasn't quite what they've been charged with, which can happen on occasion as well. So I think that point is very well made. I don't think there's anything in our provisions that should create additional risks in terms of a vulnerable person making that plea, because really we're putting the onus on the defence solicitor to advise their client and to give them the proper advice and to get to the heart of what has happened in the case, in the way that many defence solicitors would say they already do and they should be doing already.
Yes. Yeah. Okay. It is just the need that assurance is there, that particularly children and vulnerable people, adults, are not in a situation where they think that this is their way of getting out of the situation that they're in, or the place that they're sitting in a police station or whatever, and that they can have adequate representation, and that the person, the police officer, asking the questions, not only has obviously the right of the law to process the matter, but also has the ability to use their common sense and judgment of the situation so that they can advise the individual that it might be appropriate to take that legal advice before actually saying something.
And we have, of course, in relation to people with significant communication difficulties now, our registered intermediaries who can be brought in at a police investigation stage to assist the police in ensuring that they're interviewing the person in the correct way and making sure that they're understanding what's been asked of them.
And just very briefly, that also applies to somebody for whom English isn't their first language, or for whom somebody is perhaps deaf and uses sign language?
Well, in those cases, it may not be a registered intermediary that's required. It may be just an interpreter who can ensure that there's proper comprehension and understanding. The registered intermediary role is more in the nature of someone who, maybe because of a learning disability or some such, is having actual difficulty in expressing their views or understanding what's been said to them. Either their expressive or receptive language is impaired in some way. Now, we're still at pilot stage with that, and it's still for the Crown Court, but certainly for the most serious cases. And in some cases, exceptions have been made, in particularly meritorious cases outside those tiers. That provision is there. Really, what we're wanting people to do is to think at an early stage about this, and at that stage, we will be trying to ensure that the right safeguards protections are available to make sure that the vulnerable have their rights upheld.
The other side of the coin is obviously it's a welcome move in order to expedite the case.
Yeah, and we see benefits to the defendant, and we've had some helpful discussions actually with defence practitioners, and we find that their view is that in a number of cases it might make it easier for them to properly advise their clients if all of this is done very transparently.
Yes. Okay, I accept that. Thank you very much. Thank you, Chair.
Okay. Anyone else in this?
Yeah. I don't understand why the court needs to say, you know, what sentence it would have imposed if a guilty plea was entered at the earliest reasonable opportunity. Why is that necessary?
I suppose the intention there is that if someone decides to enter a plea at a very late stage of proceedings, that the court can make it very clear to them that they're not getting the maximum discount that may have been available to them had they pleaded guilty at an earlier opportunity. And just to reinforce that, a late plea won't, in most cases, get you as much discount as an earlier plea might.
But I mean, the damage is done, as it were. I mean, what's the point in doing that at that stage? What's the point of the court doing that? How does that assist anybody?
Well, it probably doesn't make much of a difference in that particular case, but in terms of making offenders more generally aware and their legal representatives aware, it creates hopefully more. It goes back to the point I made to Mr. Dixon about more transparency in the system, about how the system of early guilty pleas operates.
Yeah, but it's a self-evident proposition that if you plead guilty late on in the day, you're going to get a heavier sentence than you would have got. And that stands to reason, doesn't it?
There was a point that was made to us during consultation that there's a degree of knowledge out there about credit for and a reduction for an early guilty plea, but that it would be helpful if there was greater transparency and there was almost a way of advertising that. And the intention behind that clause is essentially, and I take the point you make, it's sort of closing the door after the horse is bolted.
Yeah.
But it's intended to build up over a period of time, almost to enhance the sentencing guidelines that the Lord Chief Justice has promulgated. But it's just to increase awareness and build up a greater knowledge that credit is available in certain circumstances.
Yeah. Then the next provision, the duty of the solicitor to advise a client about early guilty plea. If a solicitor doesn't do that, then they are in breach of the regulations that will be devised in relation to this. Is that right?
Well, the clause as currently drafted provides that the Law Society would make regulations in respect to the giving of advice.
Yes.
And the reason that was drafted in that way was as the duty to advise touched on professional obligations
Yes.
of a solicitor. We felt it was probably more appropriate to leave that to the Law Society to regulate.
So they regulate, they'll devise these rules,
Well,
these regulations, and then...
Sorry, what I was going to
Sorry.
go on to say was that one of the amendments that is before you today is to remove that subsection
Right.
on the advice of the Attorney General.
Right.
Because the Attorney General commented that as the clause already sets out the nature of the duty and the penalty for failing to comply with the duty, 78.3 simply placed a regulatory burden on the Law Society that could be dispensed with. So that regulation-making power.
Well, what is the penalty if a solicitor contravened this section? Is it?
It's set out in clause 78.5.
Yeah, any person may make a complaint in respect to the contravention of the solicitor's disciplinary tribunal. Is that? And then you get into all sorts of problems about who's telling the truth in this matter. Is the client telling the truth, or is the solicitor telling the truth? And then there's all sorts of issues about client-solicitor confidentiality. And has that been addressed?
Well, I could start by saying that the drafting of the clause closely follows the provisions in the Justice Act 2011 on the giving of advice by a solicitor advocate.
Yes.
So it's broadly constructed in a similar way. Now we have had some engagement with the Law Society in relation to the clause. I haven't specifically discussed that issue, nor has it necessarily been raised with us, to my knowledge, by them.
Yeah, but it just seems to me that any solicitor with his or her salt is going to advise their client in relation to pleading guilty if there's grounds to plead guilty, and to do so expeditiously. Right?
Well, the Law Society would say that their belief is that in practice most solicitors would routinely be doing this, so
Yes.
it's not a
Yes.
significant departure from what is regarded as, as current best
but my
practice.
point is, why do you put this into legislation if that's being
This
done?
actually arose during a discussion at committee when we came to brief you on the outcome of our consultation on
Yeah.
early guilty pleas. It was actually Mr Weir at the time
Yeah.
had made the suggestion, and then following our appearance, or sorry,
And Mr. Wells.
and Mr Wells as well.
Yes.
And then following that, the committee chair, I think, wrote to us
Yeah.
to ask the department whether we'd considered the suggestion and whether we were willing to accept it. So we said that we would, on foot of the briefing we'd provided on the outcome of consultation.
Yes. Sometimes I disagree with Mr. Wells. I think Mr. Weir as well.
But we did,
But
write,
I just
we did
don't-
write to the committee on that occasion,
yeah.
so I'm
No,
hoping
I-
that all members would have had sight of the correspondence at the
I
time.
understand the history, but it just seems to be unnecessary in all the circumstances. And I think it'll create a lot of problems because, well, not a lot of problems. It could create, potentially, could create problems because of conflict between a solicitor and the client. And the client could perhaps even use a purported or an alleged breach of this duty to advantage that person in the justice system in some respects. So I just think it's unnecessary and it could give rise to some problems. Even though it's well intentioned, I'm sure it's very well intentioned. I'm sure Mr. Wells intended it properly.
Sorry, Chair, as Alban said, he doesn't think that the actual clause itself is necessary.
I don't think it is necessary.
Well, just clarification.
Yeah, well, that's my political view.
Okay, Patsy?
Yeah, thanks, Chair. It's just back to the point that Alban was making around somebody admitting that they were guilty say, halfway through, and the judge saying, it's from the presentational point of view, the judge saying, for example, if it was a brutal crime, probably with a lot of media attention around, the judge says, you would have got 20 years, but I'm giving you 14 years. Now, in a lot of cases, forgive my degree of cynicism, but people usually admit guilty because the writing's on the wall. The solicitors told them, hey boy, you're going to get the hammer here anyway. You're better admitting guilt. So I'm thinking from a presentational point of view, and there may well be families and victims of brutal crimes who are looking at that situation and say, that boy should have got 20 years, and look, the judge has pulled out just because in a cynical exercise he has admitted he was guilty. From a presentational point of view from the court, I think that could potentially create a fair number of problems than it could actually solve in terms of being transparency and all those sorts of things. I remain to be convinced, basically.
I think, though, that the circumstances that this clause is intended to address is where someone could have pleaded guilty earlier but didn't. So
yes.
they've maybe made the victim go through the trauma of giving their evidence and then entered their guilty plea, whereas they could have reasonably entered their plea before that happened. So it's to allow the judge to say that as a result of having put the victim through that ordeal, they are getting less of a credit or discount than they would otherwise have done, as opposed to the scenario that you're talking about, where it's more about, I have given you extra credit because it was early.
I don't know. Let's still remain to be convinced, but thanks for shedding some light on the thinking around it anyway.
Okay. No, Patsy, yeah?
Yep, thanks, Chair.
Raymond?
Just a couple of points. My understanding is that the Law Society aren't happy that they will be put in a position that nearly becomes part of their responsibility. You know, Owen's right that they might say, any good solicitor will advise a client know of all options, but I think they have this sort of feeling that they might have their statutory responsibility might just pose them a bit of a problem. So I think maybe just have to come back to that in the future.
And we would,
just in relation to that, sorry,
Mr. Carter, I was just going to say, we would absolutely accept that a solicitor acting in the best interest of their client would properly advise their client at appropriate juncture. We would accept that.
And the other aspect of this is that you see that the actual process. If there's a charge laid against someone, will it be a part of the process where they say they plead guilty? It might be for a lesser charge as well. You know, we see that often at the door of a trial, say that a person might be charged with grievous bodily harm. You know, the prosecution might say to the defence, if there's a plea for actual bodily harm, then we might look at it favourably, and the person changes their a plea from not guilty to grievous bodily harm.
You're not trying to go down the road of plea bargaining here, which I think is your underlying concern. Now, I'm sure there are circumstances where at an early stage in considering a case, depending on what the accused discloses, the PPS might review what the appropriate charge is in the case. You know, someone could say, well, yes, a typical one would be, yes, I did possess marijuana, but it was for personal use. It wasn't with intent to supply. So the PPS might look to see, well, will we charge them with? But we're not talking about brinkmanship at the door of the court in an effort to get a reduction in the charge, which would be getting you into plea bargaining, which is a different thing. And that's not the policy intent behind the clauses.
But a person may have made no admission, that, say arrest, no admission, and then they're presented with the charges. They might say to their legal brief, look, I mean, your scenario, yes, I had the marijuana, but it wasn't me. But they're charging me with the sales, so I'm going to fight that. Whereas if they were given the opportunity to go for the lesser charge, they might plead guilty. So how do we fix that scenario?
I think that's, again, referenced in the pilot that we have underway in the Crown Court, where we think that one thing that we would like to see happening in the future in cases is earlier disclosure to the defence from the prosecution, an earlier discussion between police and prosecution about what the appropriate charges in the case should be. At the moment, both sides seem to like to play their hand very carefully and not disclose more than they're required to. But we think there should be the scope for an earlier resolution of cases or a narrowing of the issues if you had that greater transparency in the process, so that better informed decisions could be made at an earlier stage in the process about how the case should proceed, which I think goes a bit beyond what we're talking about here in relation to earlier guilty pleas. But I think all of these things connect, and it's a point the Law Society has made in the past that very often the reason there'll be a reluctance to enter an early guilty plea is because the defence aren't aware of the full strength of the case or the evidence against the person. So really, in fairness, the defence should be getting more information earlier from the prosecution in order to create a level playing field.
And what stage then is it considered not an early guilty plea?
We've avoided trying to define what this earliest reasonable opportunity is, and that came out quite a lot in the consultation responses. What does that actually mean? Because it's going to be so case specific, and we think really that is something that has to be left to the discretion of the judge to determine in the particular circumstances of that case.
But I mean, just to satisfy, in terms of the interest of justice, say someone does, the temptation is that someone might plead guilty early because they're saying if you don't plead guilty, then you get a heavier sentence. But then something comes to light that would sort of necessitate that the pleas changed. Is there a process to fix that?
There is a difference between indicating an intention to enter a guilty plea and the actual admissibility of a formal plea. So in those circumstances, I would have thought that if someone has just indicated, they can still change their plea if something comes to light. But even that indication could help to speed the case up because, for instance, in ours, we're finding that the police are having to request fewer forensic exhibits because they're fairly confident the case is going to go a particular way. Now, if something came to light and the person said, well, I know what indicated an early guilty plea, but I've now reconsidered, then they could go and pursue those other lines of evidence. But in a lot of cases, I think, provided they're aware of the case against them and aware of what the consequences might be of pleading later, the person is unable to make a properly informed decision at that early stage.
And say someone did go for an early guilty plea and then changed their mind. No, that can't be part or form part of the trial. When they say that prosecution couldn't ask you in the box, did you originally say your intention to plead guilty in this, what way you change your mind?
Well, I think it would depend then on what reason they were given for why they changed, and it may be that having discussed further with their solicitor, they've decided that that isn't what they intend to do. And I suppose to meet the sort of circumstances that Mr. Dixon was talking about, if somebody maybe was vulnerable, if it came to light that there was a vulnerability, the solicitor might go back to them and say, well, I think we need to look at this again. You were a bit too quick to admit to that and maybe didn't understand the full consequences of what you were doing. And in that case, you would think the judge would take that into account.
Yeah, but it is disclosable. Like, I mean, if a person indicates that they're going to plead guilty, then it can be brought out at trial that they indicated they're going to plead guilty.
I think so.
Yes, I
think so. I mean, an indication that I'm going to plead guilty, I could withdraw that at any time, up to the point where I actually formally enter my plea.
Yeah. I see. We just add sort of a line between, someone charged with grievous bodily harm and actual bodily harm. And you see that particularly in domestic violence cases.
Yeah.
Where grievous bodily harm can be appealed, but actual bodily harm can't be in terms of leniency. And some type of grey areas you might try and avoid, and it's a loophole, or someone might be advised. What's actual bodily harm, what's grievous bodily harm, but then when they're confronted with it in the box, so you pleaded guilty earlier on for grievous bodily harm, why should we believe you that you hadn't got it? So it's just that hypocrite.
If the individual hadn't had the benefit of legal advice at the point that they they made that admission, then I think it would be reasonable to say that they needed to take that advice into account.
Okay, thank you.
Okay, Tom?
Chair, thanks. Thanks again for the presentation. I suppose I've always had a bit of concern about this section as well, and that it has potential, as been highlighted already, to be exploited to some degree, in that those that are being charged or do feel under some pressure to take a more lenient sentence if they plead guilty, even though they may not be guilty. And no matter how you dress it up, that will be an issue. I have no doubt about that. I do see the reasoning behind it to try and stop maybe from putting victims through the torment of going through a case. Quite interesting though, I have, and I'm sure other parties are aware of this particular case as well. I think that the family had lobbied other individuals and MLAs as well. And that is where a family, where there was a deal done between the prosecution and the person that was guilty of an incident in which a person had died. And that person's family who had died felt that they didn't get their day in court because the case didn't run to court.
Yeah.
Now, I know it's an exception, maybe one of the few exceptions, but they feel that they had a lot to offer, and they felt that the person was too lenient then, because they weren't able to tell us the torment and the difficulty that this person, because of their actions, had put them through. So that is the other side of the case, where the victims in that incident wanted to go to court.
Yeah. We did ask victims' organisations about that at an earlier stage, about whether, if there were more early guilty pleas, whether victims would feel that way, and they felt that you'd probably get a different answer if you asked someone who'd never given evidence in court than you would get if you asked someone who had, because it's only when they get into the court setting that they realise what a traumatic experience that can be and how daunting it can be. But I suppose what might help to mitigate against that is the fact that in the case of an early guilty plea, a victim should still be able to put forward a written statement, which we've provided for elsewhere in the bill, which is done at the moment on a non-statutory basis, but we're putting that in statute.
Are those always accepted at present? Sorry for cutting across you there, Mara, but are those accepted at the moment?
Yes, as far as I'm aware. I'm not aware of any instance where the judge has refused to accept those.
And is the victim always informed of that?
Yes, at the decision to prosecute stage, they're informed by the PPS at the moment that they have the facility to make a victim statement. So they should be aware of that, and certainly we'll be trying to promote the use of victim personal statements on foot of the legislation as well.
All right, thanks, Chair.
Okay, Tom, no one
Chair, just one point. Just the duty is on the solicitor. It's not on counsel.
It's not, and a couple of people did raise that point during consultation.
You say counsel advises you. You shouldn't be pleading guilty here. The solicitor has already advised you should plead guilty.
I suppose
it seems, I think it could become problematical in those circumstances. And of course, the solicitor can't say, well, counsel told me to do this or do that. Or the client, and the barrister can't say, well, I told the solicitor to do this or that.
I suppose here we would want to differentiate between making people aware of the fact that there may be credit for an earlier plea,
yes,
as distinct from telling them what their plea should be. I think those are two different propositions.
Yes.
We would be concerned actually if counsel as well as the solicitor were reminding the client of the credit available, that you could be starting to get into the territory that we talked about, where people might start to feel pressurised. If two legal representatives are both raising that point with them, it may start to feel as though they have more pressure on them to admit their guilt. This is really just about making sure that the information is provided to the defendant at an early enough stage in the proceedings, that they are aware that
yes, but
there are implications for them of when they might enter a plea.
The obvious, if you're reminding the client will then say to you, well, should have plead guilty. Or should I not?
Yeah.
Where does It seems to me that you raise a lot of hair.
In terms of the duty not being on council, there's probably a couple of rationales for that.
Yeah.
Firstly, obviously, we may not have counsel in every case,
Yes.
particularly in the magistrates' court. Secondly, we would sort of expect that the duty on the solicitor would be, in practice, would be an enduring duty.
Yes.
So that at different points throughout the preparation for the case, perhaps once in the police station, once when the PPS have disclosed a certain amount of the case, perhaps again when counsel comes on board, that it would be an enduring duty. So if counsel, in the situation that you raised where counsel and solicitor had a fundamentally different view, one would expect the advice to be given again to the client. So it's essentially that's why it's on the solicitor as a sole point of contact, as opposed to having it on counsel as well.
Yes. Of course, a barrister could change, a solicitor normally would change.
Absolutely, yes. And in any event, there will always be a solicitor instructing counsel, so that's the point of continuity.
Thanks very much.
Okay, thanks. If we move on then to Party Act clauses 79 and 80, avoidable delay in criminal proceedings, clause 81, public prosecutor's summons, clause 83 that covers powers of court security officers, part 9 that covers supplementary provisions. So again, whenever you're ready, if you want to brief us, and then we'll open up the questions.
Yes, starting with statutory case management, clauses 79 and 80 create a statutory framework for the management of criminal cases. These provisions are the Department's response to the Committee's recommendation in the report of your inquiry on services for victims and witnesses that case management should be placed on a statutory footing, and also responds to a similar recommendation made by Criminal Justice Inspection. The clauses will create a general duty on everyone working in the criminal justice system to reach a just outcome as speedily as possible, and enable the Department to bring forward regulations to set out the duties of the court, the prosecution and the defence in relation to the management of criminal cases. We've specified that the regulations must take particular account of the needs of victims, witnesses and children. The regulations would aim to make clear what is expected of both the defence and the prosecution by the time a case reaches court, and they would empower judges to ensure that the regulations are applied. We hope they should lead to a reduction in the number of adjournments prior to the start of trial, fewer witnesses being called to court unnecessarily, and speedier progress of cases more generally. We've shared with you proposed amendments to these clauses, which were recommended by the Examiner of Statutory Rules following his scrutiny of the Bill's Delegated Powers Memorandum. In essence, the amendments address the Examiner's comments that the two separate regulation-making powers currently in clauses 79 and 80 could be combined into one, and that the regulations should be subject to statutory consultation with the Lord Chief Justice, the DPP, the Law Society and the Bar. In terms of consultation responses, there was strong support in principle for these provisions. Issues raised included what we mean by just outcome and whether this is the right terminology to use, whether the regulations should apply to the prosecution service and what sanctions could be applied. Clause 81 will allow public prosecutors to issue a summons to a defendant without first having to get a lay magistrate to sign it. We hope this should help to reduce the time taken between a decision to prosecute and the first appearance in court. And again, there was a mix of views on this provision during consultation. The Law Society took the view that this is a judicial function and more properly the role of a lay magistrate. The PPS welcomed the new measure, which they say will allow them to submit complaints electronically to a court office as opposed to the current manual system. So we're happy to take questions on the remainder of the Part 8 provisions.
Have you any comments specifically on Part 9 or?
Other than to say Part 9 is fairly technical in nature and sets out supplementary provisions pertaining to the Act as a whole.
Okay. When we're told things are technical in nature, it always is a little bit more interesting. You always want to delve a little bit more into it. I mean, Clause 86 is one of these clauses that I think we're all seeing increasingly on all bills that are put through the Assembly, and departments like to stick this sort of clause in at the end of a bill. not just in the Northern Ireland Assembly, I think it has to be said across the United Kingdom as well. Supplementary, incidental, consequential and transitional provisions, etc. What does that mean?
Excellent question. I'd begin by saying it's a general construction that's used, as you pointed out, in lots of pieces of legislation. Simply where Legislative Council will draft something like that to cover various eventualities.
And particularly a bill of this size, where you've, maybe the potential for an issue to arise in a number of areas that might need some rectification. But it is intended to address any sort of minor points that might arise rather than anything which is standard policy.
I would perhaps suggest it's a bad habit that departments have got into. Is there any limitations on what that would mean? I know you're saying it's for minor things, and we often hear that, not just from this department. Are there any limitations on it?
I would need to look at it in detail, Chair, to be honest, and be happy to come back to you on that. The one thing that I would say, however, is the committee will, I'm sure, have had the benefit of the examiner of statutory rules and consideration of delegated powers and the various housekeeping pieces of housekeeping clauses in the bill. So I'm assuming that nothing untoward has been raised by that consideration. It's certainly not something that's been raised with the bill team.
But I understand that it's perfectly legitimate to have it in there. It's just whether or not it's right that departments do put that in there. I think that maybe the committee would want to look at that again.
I think just clarifying here, this wasn't something we specifically asked for in instructions. It was something that draftsman decided to include, as Graham says, because it's a fairly standard provision.
Yeah, well, we might want to break that bad habit. Sammy?
Thank you, Chair, and thank you for your presentation before. And apologies, Chair, for being in and couldn't go to that other committee. Maura, you mentioned clause 79 and you talk about a just outcome.
Yeah.
Could you maybe give us some examples of an unjust outcome and what that means for young people?
I suppose an unjust outcome would be if decisions were taken without all of the relevant evidence having been considered. We'd like to think that wouldn't be the case, and I suppose the formulation just outcome was something we thought best encapsulated what we're trying to achieve here, which is making sure that in trying to ensure that things progress speedily, we don't do anything that impedes against the necessity of a just outcome. So the just outcome would always have primacy here, but within that, ensuring that we're doing all we can to move cases on as quickly as we can.
Thank you, Chair.
Yeah, thank you. It's just back to the point that the Chair made. See, in relation to the clause 86, and it says, I think it's 86.2, an order under subsection 1 may amend, repeal, revoke or otherwise modify any statutory provision including this Act. Does that give the Department the power, if this is passed in the Assembly, say we're not taking it forward, we can just ban it?
Well, if we weren't going to take it forward, we just wouldn't commence the provisions, I suppose. I
understand that, but I'm asking, does it give you the power to do that? I'm not asking you, would you do it, but does it give the Department the power not to enact this if it didn't suit them?
I think the point I'm making is that we could do that even if we didn't have that provision by simply
No, I understand that. I don't doubt that the departments once they do this, but it also says any part. So say there's a part of it which there's an amendment. Say we tabled an amendment today, and it said that we wanted the PEs to go ahead. Can then the department have the power to say, well, you've already signed up to 86, which allows us to repeal or revoke any part of it, so we're going to repeal or revoke that?
I don't think in practice that's the intention behind the provision.
I'm not trying to second guess it. I'm just asking, are you giving people the power to do that?
I can't say for certain because I'll be absolutely honest with you. I'm approaching that part from a position of pure ignorance at the moment.
Yeah.
But I'm happy to take some advice on it and come back to you, or if it would help.
Because when you read the face of the bill,
Yeah.
It's allowing, once it's passed, they take any part of it out if the department, and nobody could say anything because you're given the power by if we voted.
I mean, certainly, to my limited legislative knowledge, it seems to be a standard provision. Legislative Council has come up with that construction, but as I say, perfectly happy to take advice and come back to you. Or I'll regret saying this if
It's being hand-sorted.
if perhaps during your informal clause by clause, I'm happy to come along and speak to some of those issues which I've had an opportunity to take some advice on.
I think we'd be happier responding substantively if we discuss it with the legal advisors, so that we could be absolutely clear what the effect of this may or may not be.
That's what the scope of it is.
I mean, it reads very, very simply. I mean, the reading of it just says amend, repeal, revoke, or otherwise any statutory provision, including this Act. So it's the point the Chair made. There's nobody doubting it has been done in the past, but perhaps to all our discredit, we've almost okay.
I'd be keen to clarify with our lawyers what by order means and what role the committee would have in, scrutinising anything that we would do under the terms of that provision by order. So we'll take that away and we'll get some further advice on that.
Okay.
Any other members? No? Okay. Now we'll move on to the new policy amendments then, relating to the Police and Criminal Evidence Order 1989, fingerprint and DNA retention. So, Maura, thank you. Getting away, Graham is staying. And Ian Kerr, Policing Policy and Strategy Division, and Gary Dodds, Police Powers and HR Policy Branch from the Department, are going to join us.
That's a thinking point.
You passed.
Exactly.
Okay, gentlemen, very welcome. Whenever you're ready, if you want to brief the proposed amendments for the PACE and fingerprint and DNA retention, and then we'll open up to questions.
Thank you, Chairman. Yes, briefly by way of introduction, clauses 76A to 76D are proposed amendments to the biometric provisions in the Police and Criminal Evidence Northern Ireland Order 1989, or PACE. There are 5 amendments in total, 4 of which have been drafted and have been shared with the committee today. The remaining amendment is being drafted at present, but we will outline the policy intent behind it today as well. In 4 of the 5 cases, the amendments are to address shortcomings identified through early experience of operating the corresponding provisions in England and Wales. And the 5th is to bring within the retention framework a new discretionary disposal being introduced to Northern Ireland elsewhere in the bill. Turning to the individual clauses, 76A, at present, PACE allows DNA sampling and fingerprinting of an arrested or charged person once only in an investigation. And provisions still to be commenced in the Crime and Security Act 2010 will confer power on the police to require a person to attend a police station for the purposes of having their fingerprints and DNA sample taken, if these have not already been taken on arrest. Clause 76A will amend PACE to allow police to retake fingerprints and a DNA sample in cases where an investigation has been discontinued and where the material originally taken has been destroyed in accordance with the new retention framework, but the same investigation later recommences, perhaps because new evidence has emerged. The amendment will also extend to these arrangements the CSA power to require attendance at a police station. This power must be exercised within 6 months of the date of the investigation being resumed. It is subject to the same constraints as currently drafted. Clause 76B adds a new Article 63K8 to PACE to reflect the introduction in Northern Ireland of prosecutorial fines by Part 3 of this bill. This was something we flagged with the committee during oral evidence at committee stage of what is now the Criminal Justice Act 2013. where an individual is arrested in connection with a recordable offence and he accepts a prosecutorial fine for committing the offence, we intend that their material may be retained for a period of 2 years, consistent with provisions already in the framework relating to penalty notices. Clause 76C is to replace existing Article 63N of PACE, which has been found not to achieve the intended policy outcome. As currently drafted, Article 63N requires there to be a causal link between the taking of DNA and fingerprints on first arrest and a conviction obtained following a later arrest for a different offence. Say, for example, an individual is arrested in connection with a burglary and their prints and sample are taken, and separately they're arrested in connection with, say, domestic violence and convicted of that but not of the burglary. At present, the legislation would prevent the retention of the fingerprints and sample in connection with the conviction for the second unrelated offence because the investigation of the first offence did not lead to the second arrest. So the material would have to have been taken again on the second arrest with the associated processing costs in order to be retained. The substituted Article 63N will make clear that DNA and fingerprints taken from an individual may be retained on the basis of a conviction, irrespective of whether or not that conviction is linked to the offence for which the material was first obtained. Article 63R of PACE disapplies the general destruction requirements from material to which other statutory regimes apply. One such regime is that in the Criminal Procedure and Investigations Act 1996, which sets out the disclosure duties of the prosecution and the defence in relation to criminal proceedings. For example, the prosecution must disclose to the defence any material which could undermine the prosecution case or be otherwise helpful to the defence. As currently drafted, 63R applies to fingerprints and DNA profiles, but not to DNA samples, which must be destroyed no later than 6 months from the date on which they were taken. This has been creating operational difficulties in cases where the sample becomes relevant as evidence in court proceedings, particularly samples used for purposes such as drug and alcohol use and violent sexual contact between suspects and victims. The amendment made by Clause 76D disapplies the normal destruction rules for samples in cases where the sample is or may become disclosable under the 1996 Act, but makes clear that the material cannot be used for any purpose other than in proceedings for the offence for which the sample was taken and must be destroyed once the Act no longer applies. Finally, in relation to the provision that is still being drafted, we intend to bring forward an amendment to correct a gap identified in new Article 63G of PACE, which makes provision for the retention of DNA and fingerprints taken from persons convicted of an offence outside Northern Ireland. As currently drafted, Article 63G would not permit the retention of the DNA profile and fingerprints taken from a person in Northern Ireland on the basis of a conviction recorded against the person for a recordable, non-qualifying offence in England, Scotland or Wales. I think at this point, Chairman, I should maybe explain some of the terminology in use here. We speak of a recordable offence, and those who have been through this before will know this, but a recordable offence is any offence for which an individual could conceivably receive a custodial sentence. A qualifying offence, on the other hand, is a serious sexual or violent offence, and the two definitions are used as thresholds for the application of different aspects of the framework. Anyone convicted of a recordable offence may have the material retained indefinitely. In the absence of a conviction, if the offence for which they've been arrested and charged is a qualifying offence, the material may be retained for a limited period, 3 years, with a possible further extension. And that distinction in definitions is pertinent to the difficulty we have here. The difficulty in the provision has its origin in the treatment of convictions in overseas courts. And we understand that when the provisions were being drafted, there was agreement that foreign convictions should be reckonable for retention purposes, but concerns that persons might be convicted of a recordable offence in some countries on the strength of a lower standard of proof than would be required in domestic courts. And a conscious decision was therefore taken to err on the liberal side and provide that in respect of overseas convictions, indefinite retention would be permitted only in connection with a qualifying offence, rather than a recordable one. Now, inadvertently, when the legislation was being drafted, this higher threshold was applied to convictions in Great Britain. And the amendment will therefore provide that a conviction in Great Britain for a recordable offence will be reckonable for the purposes of determining the period of retention of material taken in Northern Ireland. That's as much as I have by way of introduction. I'll take any questions.
Okay. I must say, it all seems very complicated and not easy to decipher at all. A very basic question to start off, and hopefully you have the information or you can give us some guidance. How many people in currently living in Northern Ireland will have their DNA on a database?
Yeah, figures, I think at March 2014, current figures were 123,000 DNA profiles are on the local DNA database.
123,000.
Figures in relation to fingerprints, around about 700,000 sets of fingerprints.
And in both of those figures, how many of those individuals weren't found guilty of an offence?
Good question. Under the new regime, which we're planning to bring in October, there will be around about 33,000 DNA profiles destroyed or deleted from the DNA database. These are mainly profiles from people who have no previous convictions, so under the new rules, they would be required to be destroyed. Around 91,000 sets of fingerprints would also be destroyed, come the introduction of the new system, essentially.
And who's responsible for destroying those? Under what supervision?
Well, it's police material, obviously, so it will be the responsibility of the police and forensic science to ensure that whatever needs to be destroyed under the law will be destroyed, essentially.
And I can understand for individuals who have carried out very serious crimes, sexual crimes, even burglary, issues like that, why this would be a very useful tool in terms of getting future convictions. But you've said that it will also be used for those who've accepted prosecutorial fines. Now, when we took evidence on this only a matter of weeks ago, it was very much emphasised as this is for very minor offences, very much in the lower level. But those individuals would still have their DNA.
Yes. I mean, obviously the police have a power to take DNA and fingerprints from anyone who's been arrested for a recordable offence. Some of the recordable offences will be subject to a prosecutorial fine once the bill becomes law. So in instances where the police have taken DNA and fingerprints from someone who's arrested but it subsequently accepts a prosecutorial fine, what we're suggesting is that the DNA and fingerprints would be held for a limited period of 2 years, consistent with the penalty notice provision, which is already in the statute.
And maybe worth mentioning, Chairman, that they don't have prosecutorial fines in England and Wales, they do have them in Scotland. And in Scotland, the retention regime is 5 years for a situation where the fine is awarded in connection with a qualifying offence, and 2 years where it's awarded in connection with a recordable non-qualifying offence. Now, as you say, when we looked at this with the policy leads who were considering this at the time, we took through the 2013 Act, they made clear then that there would be no circumstances in Northern Ireland where this disposal would ever be used in connection with a qualifying offence. So we have mirrored the Scottish retention of 2 years.
Okay. Raymond?
I mean, it's a similar question. Just in terms of the prosecutorial fine, this is the addition, the prosecutorial fine. Yeah. In terms of, I remember the last time in terms of penalty notice and the debate around it. Again, see in terms of a person's, like say, access SNI search, does DNA retention form part of that?
No.
No, so that doesn't be disclosed?
No, it's not remotely like having a criminal record. It's not remotely like a criminal record that you're
but even
it's anonymous.
The bigger search, and that, I know the sort of straightforward one from the Chief Constable sort of association, that wouldn't come.
No,
but any other search, DNA wouldn't. Thank you.
Yeah, Sam?
Thank you, Chair. Thank you for your presentation so far. You mentioned, Gary, I think it was, you'd mentioned about the numbers in terms of DNA and fingerprinting. How does that compare, how does Northern Ireland compare to, say, like so England, Scotland, Wales, or indeed the Republic of Ireland, and percentage-wise then, Gary?
Well, much smaller, obviously. The national DNA database in England and Wales has around about close to 5 million DNA profiles. Obviously, some of them profiles will be from Northern Ireland because Northern Ireland shares with the national DNA database. That's significantly reduced because the English have introduced their new rules as such, and over 1 million profiles had to be deleted from the national database. So, in percentage terms, Northern Ireland profiles, I think, is around about 5% of the population.
Certainly, when we were looking at this at the time we took the bill through, the situation in England and Wales was they were with about 10% of population, and on implementation of the new framework, expected to lose about a fifth of those, bringing them down to about 8%. In Scotland, it was around 6%. In Northern Ireland, as Gary says, 5%. And again, we expect to lose a fifth of those on implementation, so we should come down to 4% overall.
Okay, thank you very much. Thank you, Chair.
Okay, Edwin?
Yeah. I think many people will be disappointed that there's going to be a reduction in DNA retention. Bottom line is, if people with my fingerprints or DNA or the legitimate authorities have them, it's not an issue of concern because you don't intend to do anything wrong. So the only people who have something to fear from the civil authorities having fingerprints and DNA of individuals is people who are committing crimes. Now, I would want to ensure that legislation is robust and strong and can maximise the amount of DNA and fingerprint retention that we can achieve, whilst at the same time being human rights compliant, because I recognise that I think there was rulings from Europe on this issue, and that's probably why you're
Marburg judgment,
you're losing quite a lot of that material.
Yes, indeed.
And in terms of what you're proposing, are we going to maximise the ability of the police to maintain as much DNA profile as possible?
Well, the DNA will be retained in respect of anyone who is convicted. That's the bottom line. That position will not change. In fact, the only change that is being made by the introduction of the new framework is that indefinite retention in respect of, or in the absence of a conviction, will no longer be permitted.
Yeah. And in the case, I think you were indicating there that you could hold DNA for one particular crime, but that wasn't applicable to another crime, is that right?
Yes, the way the legislation is drafted at the moment, there is some mischief around the use of the words "leads to" in the particular clause, which means that if DNA is taken in respect of one offence, but the individual does not go on to be convicted of that offence, unless the investigation of that offence has led to the same individual being arrested for a subsequent offence, and hence leads to, the DNA cannot be used in respect of the second offence, and that was never the policy intention, so we're moving to remedy that in the amendments we're making here.
Right, thank you. Paul?
Yeah, explain to me, but though, how you're remedying that. So you've got a DNA sample. Person goes through court, is found not guilty of that primary offence, is investigated and goes through court for a secondary offence, and then is going to trial. You're telling me then you can't use that DNA sample for the secondary offence, or the second offence?
Unless the second offence has arisen from the investigation into the first offence. If that's the case, then that's possible at present, but that leaves us with the gap that we're seeking to address, if you like. And, well, I'll not complicate the issue, but...
Yeah, I mean, you're quite right. I think the problem that has arisen with the legislation is that The draftsman obviously wanted to cover a situation where someone was arrested and their DNA and fingerprints had been taken.
Yes.
That was washed against the DNA database and the fingerprint database, and it created a hit against a subsequent crime that the person had committed. What the legislation allows for is that the material for the first offence can be used to on an evidential basis to convict the person or prosecute the person for the secondary offence. So that, hence the causal link, you know. What we want to achieve here is that, say for example, someone has been arrested for a non-related offence from the first offence, that the material for the first offence can actually be retained on the basis of the conviction for a secondary unrelated offence. It's very complex, you know, but it is a...
But if you destroy, if the second offence is totally unconnected, if someone is convicted, that sample is there, and there forever and a day. Isn't that right?
Yeah.
Well, the profile generated from it, yes. The sample will be destroyed anyway, but the profile will be
profile.
Yes.
So that will be identifiable.
Yes.
So let's take, for instance, you walk into a building that has been burgled, or someone has been assaulted within that building, or an attack or something, and you get DNA samples, which you then can connect to that primary source, that first hit. Surely that's all that is done is identify suspect.
That's correct, yeah.
But surely you would then take another sample of that suspect.
Not in respect of DNA. If DNA is taken in connection with one offence and there is pending arrests for the same individual for other offences, the DNA wouldn't ordinarily be taken on each arrest event. Fingerprints are taken on each arrest event, yes, but not DNA. So what we want to achieve here is that the DNA for the first offence would be retained until an outcome was generated from any subsequent arrests unrelated to the first offence.
Yes,
and say, for example, he's had 4 pendings. And
so there's a domino effect?
Yes, that's correct. And he's convicted on for arrest number 4.
Yes.
We can retain the material, or the police can retain the material from the arrest or the DNA taken for the first arrest on the basis of a conviction for arrest number 4.
Yeah.
Totally unrelated to the first offence, which and that's where the legislation's incorrect. You know,
there's a blind spot or a gap.
There is. Yeah.
But why can you not just take a further sample?
Well, you can, but there are costs associated with that. There are processing costs, and that basically we're trying to avoid the situation. We're trying to obviously keep the costs to a minimum, but avoid the situation where the police, as would be the case at present, would think they had to take, or not at present, but under the provisions once implemented as they currently stand, where the police would know that if they'd arrested someone for an unrelated offence, they were going to have to sample and process again.
Yeah. So. And there's bound to be fundamentals here, which I ignore excuse my ignorance. Why can we not retain DNA, even if someone has been proven innocent?
Well, I mean that's the whole basis of why we've changed the law. At the moment, the current law allows indefinite retention when someone's material is taken, irrespective of the outcome of that arrest event.
Essentially, it's because in order to be compliant with the judgment of the European Court of Human Rights, that has been the driver.
So Strasbourg and Westminster have taken civil liberty protection from Westminster's also legislation.
Yeah, but if and again, I know this is an argument, a debate for an hour arena and our forum, but dental records are available, are they not?
Sorry?
Dental records. Are they available?
Not. Well, certainly this legislation relates to DNA and profiles and fingerprints. Dental records.
Why I'm asking questions around that is surely, in essence, what everyone wants is for criminals or people who commit an offence to be detected, detained, punished, and justice to be served. And I suppose I would be for giving any establishment that investigates law and serves justice all the tools and power to do that, within, of course, restraint and limitations, of course. But if we have dental records, if we have fingerprints, if we have things that can help in that detection, surely that's a good thing. And I suppose, how will this hamper destroying of samples? How will that? How big an impact will that have on crime detection?
Well, I mean, obviously, if you're deleting quite a significant volume of profiles from the database, then the impact of that is that there's less profiles on the database to create or to generate subsequent matches, you know, from crime scenes in the future. It remains to be seen what impact that has going forward. But I mean,
there is no doubt there will be
yeah,
a loss of investigative capability as a result of this.
I think we have to accept that, yeah.
But yes, we have always known that.
Yeah.
Just no choice.
No choice. We have to comply with the judgment, and a move away from what we have at the moment, which is a blanket indefinite destruction, to something which is much more structured and related to conviction and non-conviction type instances.
Are you, and I suppose that's a sweeping question, broad question, but are you satisfied that everything within the amendments can push that legal requirement to destroy, and has pushed that right to its limits with regards to the?
Well, certainly everything that we're doing within the amending provisions that we're introducing now is aimed at, well, with the possible exception of the new material relating to prosecutorial fines, is aimed at improving the existing provisions in the bill, and improving in the sense of plugging gaps in them so that material that would otherwise be lost, or thresholds that wouldn't be met, will in future be met and recovered, if you like. So it's refinement, but it's refinement in that direction, certainly. That's how I would characterise it.
Yeah.
Okay, Chair.
Simon indicated he wanted to.
Thank you, Chair. I was going to ask you two quick questions. I'm not quite sure I'll be able to answer the second one. The first one is in relation to the National Crime Agency, and I think you had said there's going to be a reduction, it's about a fifth in terms of the figures. I assume that with the operation of the National Crime Agency that will increase more people to be fingerprint and DNA and that as well. Obviously there'll be more activity, arresting criminals and gangsters now.
Well, I mean,
it will be another agency. It will be bringing more resources to bear on criminal elements, and you would imagine as a result of that there would be, as you say, an increase in activity and an increase in product for the biometric system, certainly, yes.
And just in terms of fingerprint and DNA, at this point in time, again with the operation of the National Crime Agency, can they introduce DNA and fingerprint, say, if they have taken fingerprints, say, from criminals and who originally came from Russia or whatever, or somewhere, some of the more international communities?
I think of the law enforcement agencies operating in the UK who have powers of arrest, and if it's a recordable offence committed in the UK, that material will go onto the database. And we have provisions elsewhere in the legislation for the entry on the database of material from persons convicted of offences overseas. So wherever they come from, yes, we should be able to.
Okay, thanks so much. Thank you, Chair.
Okay. Everyone else happy enough? Okay, that's great. Thank you very much. Appreciate that.
Thank you.
Okay, members. The Department also provided the text of its proposed amendments relating to Lands Tribunal salaries, the creation of offence of causing or allowing serious physical harm to a child or vulnerable adult, and relating to sexual offences against children. The relevant papers, members will find at tabs 19, 20 and 21 of your hard folder that you were given included for today. The committee previously considered and agreed it was content with these proposals, so are members happy enough to note that unless there's any further information anybody requires? Happy enough? Okay, then if we move on to agenda item 7, which is the draft statutory rule, can I refer members to pages 17 through to 59 of the meeting folder? The Department is proposing to make a statutory rule to establish a procedure for appeals against decisions and applications for funding by way of civil legal services and provide for the establishment and composition of independent appeals panels. The committee agreed that it was content with the proposals at the meeting of the 14th of January 2015. The Department laid the statutory rule, which is subject to the draft affirmative procedure, on the 26th of January. There have been no changes to the policy content since the SL1 was submitted to the committee, and the examiner of statutory rules has confirmed he has no issues to raise with regard to the technical aspects of the rule. The Department is proposing that the regulations will come into operation on the 1st of April 2015. So can I ask members, are you content with the statutory rule? And if so, then I'll put the question that the Committee for Justice consider draft statutory rule SR, the Civil Legal Services Appeal Regulations Northern Ireland 2015, and recommends that it be affirmed by the Assembly. Agreed?
Agreed.
Agenda item 8 is draft statutory rule. Refer members to pages 61 through 77 of the meeting folder. The Department is proposing to make a statutory rule to provide for the disclosure of information which is furnished to the Department of Justice in connection with an individual seeking or receiving civil legal services. The regulations also require the provision of information from suppliers to the Director of Legal Aid casework and waive the rules of privilege and confidentiality. The committee agreed that it was content with the proposals at the meeting of the 21st of January 2015. The Department laid the statutory rule, which is subject to the draft affirmative procedure, on the 26th of January. There have been no changes to the policy content since the SL1 was submitted to the committee, and the examiner of statutory rules has confirmed he has no issues to raise with regard to the technical aspects of the rule. The Department is proposing that the regulations again will come into operation on the 1st of April 2015. So again, can I ask members, are you content with the rule? And if so, I'll put the question that the Committee for Justice considered draft statutory rule SR, the Civil Legal Services Disclosure Information Regulations Northern Ireland 2015, and recommends that it be affirmed by the Assembly. Agreed?
Agreed.
Okay, agenda item 9. Refer members to pages 79 through to 83. The Department is proposing to make the statutory rule similar to the previous one to provide for the disclosure of information which is furnished to the Department or any court in connection with the case of an individual seeking or receiving representation under a criminal aid certificate granted under Part 3 of the Legal Aid Advice and Assistance Northern Ireland Order 1981 as amended by the Legal Aid and Coroners Court Act 2014. The committee agreed it was content with the proposals at the meeting of the 21st of January 2015. The Department laid the statutory rule, which is subject to the draft affirmative procedure, on the 26th of January. There have been no changes to the policy content since the SL1 was submitted to the committee, and the examiner of statutory rules has confirmed he has no issues to raise with regard to the technical aspects of the rule. The Department is proposing that regulations will come into operation on the 1st of April 2015. So again, can I ask members to be content? And if so, I'll put the question that the Committee for Justice consider draft statutory rule SR, the Criminal Legal Aid Disclosure of Information Rules Northern Ireland 2015, and recommends that it be affirmed by the Assembly. Are we agreed?
Agreed.
Agenda item 10 then, refer members to page 85 through to 103 of the meeting folder. The Department is proposing to make such a rule under powers conferred by the Access to Justice Northern Ireland Order 2003 to make provision for the circumstances in which cost protection will apply and while it will not apply in civil cases in which legal aid has been a feature. The regulations set out the periods in which limit liability under an order for costs against a person receiving funded services as part of civil legal services apply. The committee agreed that it was content with the proposals at the meeting on the 14th of January 2015. The Department laid the statutory rule, which is subject to the draft affirmative procedure, on the 20th of January 2015. There have been no changes to the policy content since the SL1 was submitted to the committee, and the examiner of statutory rules has confirmed he has no issues to raise with regard to the technical aspects of the bill. The Department is proposing that the regulations will come into operation on the 1st of April 2015. So again, can I ask members if we're content, and if so, I shall put the question that the Committee for Justice consider draft statutory rule SR, the Civil Legal Services Cost Protection Regulations 2015, and recommends that it be affirmed by the Assembly. We agreed?
Agreed.
Agenda item 11, refer members to pages 105 through to 115. The Department is proposing to make such a rule, which will be subject to the negative resolution procedure, to enable Access NI to search for details of an individual's criminal record on the Police National Computer. The rule also sets out the details of the information that Access NI can provide in relation to convictions on a basic check, the details of convictions and cautions that can be disclosed on standard and enhanced checks, and details of what can be disclosed and databases from which they can be disclosed. The Department stated that it did not consider a consultation necessary, as a proposed statutory rule will make technical changes to reflect the Access NI modernisation programme. So can I ask members, are they content with the proposed statutory rule, or would anybody require any further information? Content?
Content, yeah.
Okay. Agenda item 12, both Patsy and Alban asked if we could defer this for a week because they had particular interest in it. But if members are content to defer it until next week, there doesn't seem to be any urgency on it, I don't think so. Are members happy enough we defer that for a week?
Agreed. Okay.
Move on then to agenda item 13, which is correspondence. There are 7 items of correspondence at pages 149 to 271 in the meeting folder, and 2 items at pages 3 and 4 of the tabled pack. I'll draw your attention to item 3 at pages 162 to 164 of the meeting folder, which is a response from the Department of Justice to concerns raised by Randox in relation to the procurement of drug testing in Northern Ireland prisons. The response indicates that the Minister has sought and received assurances from the Northern Ireland Prison Service that the existing arrangements for drug testing are appropriate to its needs and deliver the required levels of performance and responsiveness. The response also highlights that following the CGI-NI report on safety of prisoners, the Prison Service is working to take forward the findings, including the recommendation that there should be a comprehensive substance misuse strategy based on a detailed assessment of the scale and nature of the drugs problem. That work will also examine whether the current testing regime needs to be adjusted. The response also outlines the current position regarding the procurement process now underway for the new drugs testing contract due to start in April, and confirms that the Prison Service is again participating in a collaborative exercise with the Scottish Prison Service. We will have an opportunity to raise and discuss this issue with the Prison Service when they attend in March. And can I ask if I can get agreement from the committee that we would forward a copy of this response on to Randox for their information?
Yeah, great. I think, Chairman, it's important that we ensure that there is best value.
Sorry?
It's important that we ensure we get best value.
Yeah.
And I think there's question marks that's been raised over as to whether that's the case and whether the collaboration with Scotland is delivering its best value. So a local company shouldn't get it on the basis of being a local company.
No.
But if they're being excluded and not having the same opportunities where they can offer a service at a very good value for money basis, then that's an issue of concern for all of us.
No, I agree with that, yeah. Okay, members, item 4, pages 165 to 187, is a response from the Minister to the Committee's request that he reviews his decision to close the Law Commission. The Minister has indicated that due to the budgetary pressures facing the Department, he's not in a position to fund the Law Commission or the Law Commission. His intention would be to re-establish the Commission in more favourable financial circumstances, and he's provided a copy of the report of the independent review in the Commission requested by the Committee. So that's really for noting, unless anyone has any further information required.
Move on before Alban comes back.
Agenda item 5, pages 188 to 195. Correspondence from the Committee of the First and Deputy First Minister seeking views on of the Committee in relation to the Children's Services Cooperation Bill, which passed the second stage of the Assembly on the 26th of January. OFM-DFM Committee has written to all departments on the bill, and once a response from the Department of Justice has been received, the Committee can give consideration to any relevant issues. Item 7 at pages 269 and page 3 of the table pack, a response from the Police Ombudsman to the Committee's request seeking clarification of whether the Ombudsman is currently investigating a complaint from Mr McMaster, and further correspondence from Mr McMaster in which he includes a copy of the response from the PSNI to correspondence forwarded by the Committee. The response from the Police Ombudsman's Office indicates there is no formal complaint currently being considered by the Ombudsman, and the Office is satisfied that a thorough investigation was conducted into Mr McMaster's allegations. The Ombudsman considers the matter closed and will not be entering into any further correspondence. The response from Assistant Chief Constable Hamilton to Mr McMaster highlights that he initiated civil proceedings against the Chief Constable in October 2012, and these are ongoing. Are we content there that all appropriate action has been taken by the committee in relation to this matter? And that if civil proceedings are ongoing, it would not be appropriate to consider this matter further? Just to advise members that any further correspondence received from Ms McMaster will be held in the committee office, and members will be advised that it's available should anyone wish to go and see it. Item 2 at page 4 of the table pack is a letter from Colin Stutt regarding the review of access to justice, Part 2. Mr Stutt has taken over the review from Jim Daniel, who is unable to continue it on health grounds. Mr Daniel had previously agreed to brief the committee on progress with the review, and Mr Stutt has indicated he will be happy to do so. A briefing by Mr Stutt on a review of access to justice Part 2 will be scheduled into the forward work programme. Anyone, any other issues to raise with any other item of correspondence? No? Okay. And then we shall action the other correspondence as outlined in the folder. Agenda item 14 then is Chairman's business. Item 1 is a response from the Department regarding the timescale for the Fines and Enforcement Bill. I refer you to pages 273 through to 276. A response has been received from the Department advising that there has been slippage in the timetable for the Fines and Enforcement Bill, and it's unlikely to be introduced to the Assembly before June 2015 due to the scale and complexity of the change in the law that's required for a complete reform of the fine collection and enforcement process. The Ministers offered to meet with both myself and the Deputy Chairman to discuss the overall legislative programme, including the current timetable for Fines and Enforcement Bill and its sequencing with the Medical Capacity Bill. And arrangements for that meeting will be made in the next week or two. I think growing concern that there is further slippage in this because of the work that we're going to have as a committee with the two bills. So I think if we can get that meeting arranged, it will be useful. The second item, I've accepted an invitation to meet with the Organisation for Economic Cooperation and Development to discuss the overarching themes of the first phase of its strategic review of public sector reform, which cover improving strategic approaches, improving operational delivery and improving engagement with people. And after that's happened, I'm happy to give feedback. Agenda item 15, any other business? Any members, any other business to raise? Okay. Agenda item 16, date, time, place, the next meeting. Just to remind members that we're meeting again the 25th of February, and that will take place in the NIACRO offices. We will meet with service users and staff at about 12:30. Lunch will be provided at 1:30, and then the committee meeting will start at 2:30. So we'll make sure that everybody's reminded of that close to the time, and directions and what have you will be included in that.
This is the Northern Ireland Assembly Committee Room 21. This is the Northern Ireland Assembly Committee Room